Hey everyone, welcome back to the channel. In today's video, we've got 3 major clips to dive into, including a highly awaited update from the Lindsay Duneske files, where she faces off against the firm and no-nonsense Judge Washington. But before we jump into the courtroom drama, a quick shout-out to today's sponsor, Chapter. Far too many people on Medicare end up spending hundreds or even thousands every year simply because they chose the wrong plan. And honestly, it's not their fault. Many are misled by greedy brokers chasing commissions rather than truly helping seniors. That's exactly why I'm proud to team up with Chapter. The company was founded by people whose own parents were taken advantage of by that same system, and they decided to fight back. When you call Chapter, you'll be connected with a real person who will personally guide you through every available option to find what truly works best for you. Best part, the call doesn't cost a thing. With the holidays just around the corner and an average savings of over $1,000 a year for seniors, this is the perfect opportunity to save and keep some extra cash in your pocket. So, call the number on your screen or visit the link in the description and let an expert review your options, whether you can save more or already have the best plan in place. Big thanks again to Chapter for sponsoring today's episode. Now let's jump straight into one of my all-time favorite Karens, Lindsay Duneske. Let's get into it.
We're back on the record in the case of the state of Michigan versus Lindsay Duneske. You don't need to place your appearances back on. We had a brief discussion regarding all of the filings that were filed, although the defendant has an attorney in this particular case. So at this point in time, we need to make a record of what's going on in this matter, and we can go from there. Ms. Moeller, it looks like your client submitted 4 different filings. First of all, the court has no requirement because we're not a email e-filing court to accept emailed pleadings. We did do so. Your client was advised that there is a page limit to how much we'll accept for any one hearing. So that happened, and you should be aware that that did happen as well, and that she will need to follow any filing requirements in the future. And I believe that she represented to staff that she had filed those with the prosecutor's office. Ms. Woods is indicating she did not receive them. I don't know whether they were filed with the prosecutor's office or not. Having said that, do you have a copy of the filings that your client filed with the court?
They do, Your Honor. I received those filings were sent to the court, and just now realizing they were not sent to prosecution, I have forwarded those to Ms. Woods.
Thank you.
I sent them to the other prosecutor. I apologize. Her name was Ellie, I think, because that was the one who it said she was the prosecutor for the county. So I just probably sent it to the wrong prosecutor.
So it is a he. That is the prosecutor, Ellie Savitt, and they probably did not get sent to the proper place because the way you filed them.
I filed them the way I was instructed to file them. I called and asked for instructions, and I did what I was told. So I was told that the filing requirements were to email them, and that's what I did. So, and then I was notified after the fact that there was a limit. They made an exception because they didn't notify me. And then I told them I emailed the prosecutor, verified the email. And so as far as I know, the chief prosecutor got them. I just didn't know that I was supposed to send them to the other prosecutor too. I thought, notice to agent is notice to principal. So I thought if I sent them to the main prosecutor, any of the assistant prosecutors would get them because I didn't know which one would be on the case.
Get out of here with all that sovereign citizen nonsense. Notice to the agent is notice to the principal? That might sound clever in whatever fantasy world you dreamed up this morning. But in the real world, it means absolutely nothing unless you serve the correct person properly.
Ms. Woods?
Yes, Judge. I mean, I'm just opening up one of the files now. I mean, I would need time to review all of this. I would not be able to. Yeah, I would need time to review all of these, Judge.
Thank you. All right. So first of all, Ms. Duneske has counsel. So whether or not she should or has the ability to file filings in the first place is something I'm still mulling over because she has counsel. So any pleadings should come through her counsel. And
yeah, they refused to file it. So
ma'am, I didn't say.
Oh, I'm sorry.
anything to you.
I apologize.
And then, secondly, these are not proper pleadings. They're not filed in the proper format. They're not filed with the proper spacing. They're not filed according to any of the court rules. So
They
that's
don't have to be though,
ma'am,
which I put
they do.
on there.
Ma'am, if you speak up one more time, you're going to be held in contempt of court.
But I thought this was my hearing.
Ma'am,
I should be able to
ma'am.
speak on my
All
own
right.
behalf.
You're not able to speak on your own behalf unless you don't have counsel, and you need to stop talking. One more talking, it's going to find you in contempt of court, and I'm going to give you 15 days. So please stop talking. Ms. Woods is indicating that she needs time to look at those pleadings and to be able to respond. Ms. Moeller, what is your position? I haven't heard anything from you today because she actually has.
Thank you, Your Honor. Ms. Duneske and I did, prior to the last pretrial, discuss. I didn't know exactly what she was going to be filing, but I did understand the basis of her legal argument. Her and I had a conversation where I didn't agree with the grounds for filing. It is correct that I said I would not be filing this on her behalf because I found the legal argument not to be correct. At this hearing, then Ms. Duneske did file these motions, and so I would discuss it further with my management, but I would not be proceeding with these arguments at a hearing if the court were to set it for that. I understand Ms. Duneske does want to proceed with these arguments, and I believe that she's requesting to represent herself if this court sets this for a motion hearing.
Now, Ms. Duneske, are you requesting to represent yourself?
Well, I'm asserting my right to represent myself. I'm not requesting.
All right, then if you're not requesting to represent yourself, then what's going to happen is you're going to continue to have counsel.
Well, I'm asserting my right, which is much stronger than requesting. I shouldn't have to request something that I have a right to. It just should be automatic, right?
All right.
Like the Sixth Amendment
It is not,
and the Constitution.
it is, ma'am,
Yes.
it is not automatic. So first
The
of all,
Sixth
ma'am,
Amendment says,
stop
right?
talking.
Well, you asked me a question. I'm answering under the
No,
Sixth
I heard
Amendment.
you. Nope, stop talking. So look, this is the way it's going to work. I'm going to give you what your rights are. And then if you make a choice to represent yourself, you can, after I've finished giving you those rights. Do you understand that part?
I comprehend it.
Okay.
Yes, ma'am.
So, first of all, what you're charged with is police officer assaulting, resisting, obstructing. It's an attempt. It has a maximum penalty of up to 1 year in the Washtenaw County Jail. Do you understand that part?
I comprehend that that's what you're charging with. I don't understand it because it's false.
Okay. Do you understand that that is what the maximum penalty is?
I do, which is why this is unconstitutional, because I was the victim in the case and falsely
I
arrested.
think what I'm going to do is refer her to make sure she's competent, because at this point in time, if she can't understand and she wants to use a different word, then I guess what I need to do is figure out.
Comprehend means that I know what it means. Okay. Understand means that I'm understanding the court, and I am not understanding the court because I'm challenging jurisdiction. I don't need a competency evaluation. I see a psychiatrist every month because I have ADD.
Well, then clearly you're seeing that psychiatrist for the wrong reasons. Karen.
Like me to present to you that I'm mentally fit, that's fine. But for you to say that I have to have a competency evaluation with no cause because I'm asserting my rights, that's a violation of Shearer versus Cullen. All I'm doing is asserting my right to represent myself.
Referred for competency. We'll prepare an order so she can be evaluated so we can determine.
Well, I object to that. I object to the competency
whatever
evaluation.
you want to object to, but if you don't participate, then I'll put you in custody until we get an exam done.
But why? But you have to say that there has to be a reason. There has to be a cause for it. And I have a right to know why you are forcing me to do something that I don't want to do when I thought I had a presumption of innocence. I thought I am supposed to not have my right.
For competency, you need to stop talking. And if you don't participate, I'm going to put you in custody. And I already placed on the record why.
Okay, and also, isn't the officer supposed to be here today to testify?
No, that is not how that works. See, you don't know anything about this, and that's why you shouldn't be representing yourself. But
I do. The preliminary exam was supposed to have witnesses.
This is not a preliminary examination, ma'am.
Oh, I was told. I thought that's what that was. I was just under the impression it was a
First is
preliminary.
competency, and I'm gonna schedule this for a hearing on November 20th in person, so we can have these conversations in person and see if they go any.
Well, I don't have any way to get there. I live very far away from where this is now.
Then I think when you get picked up and you're required to come here by police, then you'll have a way to
But
get.
why would that be necessary? All I'm asking, I'm challenging jurisdiction, which I'm allowed to do without being retaliated against. You're retaliating against me because I'm challenging the jurisdiction of the court. And that's a violation of my rights.
Okay, Ms. Duneske, you either need to be here, you need to participate in the competency, and you need to be here on November 20th, or you will
Well,
be.
I'm going to be filing with the Court of Appeals on this
Go ahead, ma'am.
and the Court of Claims because this
Thank
is
you.
not okay.
All right. Bond is continued for now. Once you get the notice of your actual interview from the forensic department, if you don't participate, I'll issue a bench warrant.
Okay, well, like I said, I'm going to be objecting to.
It's pretty clear Judge Washington has reached her limit with Lindsay Duneske for the day. Still, her case seems to be moving forward, so we'll likely have more updates soon. But now, let's shift over to another powerhouse on the bench, Judge Simmons, who had to deal with not one, but two clueless defendants on the same docket yesterday.
On the record in the matter of credit acceptance versus Ashley Brown, 22-013536GC. Appearance, please.
Good afternoon, Judge. Francesca Servi for plaintiff P87205.
Okay, you're Ashley Brown?
Yes, I am.
Okay, today was the date that was scheduled for a hearing. This is for an objection to periodic garnishment. We received an objection from you, Ms. Brown. It states that you are objecting to garnishment because you was improperly notified of any, does that say hearing?
Yes. So I did some research, and it appears that they reached out to a few of my other jobs, like Kirchhoff, Champion, and I didn't get any notice of any of those. I feel like the only reason I got this one is because they sent this certified mail, and I handle all the mail for my new job here at the Funeral Directors Association. But they garnished my taxes. I was not notified of any of that. When I've only found out that they garnished the taxes when I called the courthouse when I received this notice, because I was like, because they did, I saw the taxes were taken, but I didn't really look into it. But then I called the court once I received the garnishment, and they were like, oh, well, they garnished your taxes for this particular matter. But I was never given any notice.
And why on earth would they send you a notice of garnishment? They're required to inform your employer and the IRS, not you directly. They've got no legal duty to notify you.
Did you want to respond to her objections, counsel?
Yes, Judge, I will. Plaintiff had the writ of garnishment properly issued. It looks like that was back in July, so July 23rd, 2025. The writ was issued by this honorable court and then served on Garnishee Michigan Funeral Directors Associations, Inc. There's no court rule or statute or case law upon which plaintiff is aware that plaintiff is required to give defendant prior notice of filing its writ for garnishment, but the writ was otherwise properly issued by this court. And plaintiff would further note for the record that it sees that defendant was the person who signed the green card on the delivery of the writ of garnishment, and plaintiff still has not received the garnishment disclosure pursuant to that, despite now having noticed that defendant is the person who signed the green card, as well as, her admitting in court that she got it. So a plaintiff would ask that you deny the objection to garnishment as it's invalid. There's not a requirement that plaintiff's aware of that plaintiff has to forewarn a defendant about a writ for garnishment that was properly issued.
But you are still required by Michigan rule to notify me to. I'm sorry.
Ma'am, that's not how this works. You see how I asked her if she wanted to respond?
I understand. I'm sorry.
Okay, that's why I'm here. I'm the referee here. I get to mediate this. So you don't talk back and forth, you talk to me. So the court rule for your objection to garnishment is very clear. And there's no court rule that allows or tells you that you can even file a garnishment. That you see where you request the objection, and it gave you a section A, B, C, D, E, and F. Okay, and that's because those are actually the only ways in which the court rule allows you to object to a garnishment. You checked F, which allows you to say that the garnishment or the writ of garnishment was issued improperly or otherwise invalid, and then you wrote in that it was because it was improperly notified of any. You wasn't properly notified of any hearing. There's no hearing that comes with. You're opening your mouth to talk over me while I'm talking. There's no hearing that comes with a writ of garnishment. So I don't know what hearing you were looking for. There would have been no hearing. The other thing is, you said that it was not issued, or that writ issued after the initial hearing. Again, I don't know what you mean by initial hearing.
It's my turn to speak. I'm sorry.
That's correct. Yes.
So when I wrote this, it's because I literally was not notified of any other hearing even leading up. That's what I meant by hearing. So like, I understand that they issued the writ of garnishment, but I was never notified about a hearing for the judgment or any of these other garnishments. How am I supposed to respond to a garnishment if I don't have the?
Once again, they don't have to serve you separately for a garnishment. You were already served for the original lawsuit. Like so many others we've seen, you only started taking it seriously once your paycheck started shrinking.